India Legal presents Courts Roundup.
Hello, I'm Hishe and you're watching Courts Roundup. In this program, we bring you the latest legal news and details of court proceedings. Before we begin, here's the headlines. Supreme Court reserved order in plea seeking refund of airfare for tickets booked during COVID-19 lockdown. Center says credit shell facility could not be availed by travel agents. Supreme Court issues notice to matter of a postponement of UPSC exams to Center and UPSC. Plea seeks postponement by 2 to 3 weeks due to COVID situation. The Bombay High Court refuses to allow a plea for the reopening of places of worship in view of prevailing COVID situation, says decision is of the state government. And Allahabad High Court issues a writ of a mandamus for Uttar Pradesh, says no person should be seen outside house without a mask.
India Legal presents Courts Roundup.
The Supreme Court reserved orders in the plea seeking refund of airline tickets booked during the COVID-19 lockdown. The order was reserved by a bench of Justice Ashok Bhushan, R. Subhas Reddy and M.H. Shah. When the matter was taken up, Solicitor General Tushar Mehta clarified that the Center stand that the credit shell facility could not be availed by the travel agent who booked tickets during lockdown. He said so far as travel agents are concerned, we cannot regulate them. We don't have control over it. But suggestion is that a passenger can use the credit shell only through the agent. Justice Reddy then asked if the credit shell is not used till the deadline, will the money go to the account of the agent? Solicitor General Tushar Mehta replied that the government could not control contractual obligations between agents and passengers. On how transferability of these vouchers can affect, the court went on to ask if the passenger surrenders the vouchers before the agent and the same is refunded. Mehta responded, we have no problem with that if the passengers get their money back by surrendering the vouchers which is surrendered before the agents. Some UPSC aspirants have petitioned the Supreme Court asking for a postponement of the upcoming civil service examination. The court today issued notice to the Union Public Service Commission and the Union of India. The petitioners seek the postponement from its current schedule of October 4th by 2 to 3 months. This is to allow time for the COVID situation to get better and for the state government to be more prepared with the proper guidelines for the exam. In the present situation, conducting the exam with so many aspirants may further spread the virus, says the petition. The plea was filed by Advocate Alok Srivastav on behalf of 20 UPSC aspirants. According to them, the calendar for UPSC exam is arbitrary and violative of the right to health and life of the aspirant under Article 21 of the Constitution. The petitioners have contended that they may not be able to take the UPSC examination due to fear of risk of illness or death, and the revised calendar is therefore violation of their right to practice their chosen profession of serving the public under Article 19(1)(g) of the Constitution. The Supreme Court dismissed as withdrawn a PIL filed by Ajay Kumar seeking direction to the Election Commission of India to postpone the general election for the Bihar Assembly in the wake of COVID-19 pandemic. A three-judge bench of Justice Ashok Bhushan, R. Subhash Reddy and M. R. Shah observed that the Election Commission will take care of all concerned. The Election Commission has recently issued a statement to conduct the election of Bihar Assembly on schedule and has now even announced election dates. The petitioner said that a similar petition had been dismissed earlier, but the situation on the ground has not improved. The bench stuck to its ground and said that it cannot pass such an order. The bench said in an earlier order, we had noted that the Chief of Election Commissioner will take care of all the issues. At that, the petitioner asked the liberty to make a representation with this PIL before Election Commission of India. To that, the bench agreed. The PIL had said that it was not possible that election would be held smoothly within this COVID-19 pandemic. The petition said that it is well known that the right from the notification of the election till the result of the election, the interaction of person will be unavoidable. The PIL reminded that as per the guidance of WHO, all interaction should be avoided. Hence, the holding of election in the current scenario can be dangerous. The petition also said that the state of Bihar had already experienced violence during campaigning, and this is not a matter of just 1 or 2 days, but involves a month. The conducting of the virtual election can be unfair and just to people who are admitted in hospitals, home quarantine and containment zones. The Delhi High Court has dismissed a petition challenging the process of appointment of Vice Chancellor of National Law University, Delhi. The single-judge bench of Justice Jyoti Singh dismissed the petition filed by NLU Delhi faculty member Dr. Prashant Su. The petitioner had joined NLU Delhi in 2009 as an associate professor and was promoted to professor in July 2015. Certain that he fulfilled all conditions of eligibility contained in the advertisement calling for application for the post of Vice Chancellor, the petitioner applied for the same. It was his grievance that in spite of fulfilling the eligibility requirements and having a glorious academic record, he was not called for the interview round that was conducted in February 2020. No reason was provided for the same. The petitioner argued that the selection committee's decision of not calling him for the interview round was grossly illegal, arbitrary, unreasonable, and not germane to the principle of intelligible differentia. Opposing the petition, NLU Delhi had contended that the petitioner did not meet the eligibility criteria as defined in the advertisement calling for application for the post of Vice Chancellor. Senior advocate Rajiv Bansal and advocate Karan Sunjay Jha appeared for the petitioner. NLU Delhi was represented by advocate Raj Shekhar Rao, Sanjay Vaishta, S.D. Sharma, Anand Venkata Ramani, Areb Namula. The Bombay High Court has refused to allow a plea by association for aiding justice for the reopening of the places of worship in view of prevailing COVID-19 situation in Maharashtra. The bench, comprising of Chief Justice Dipankar Datta and Justice G.S. Kulkarni, said, taking judicial note of the given situation prevailing in the state of Maharashtra, we are not inclined at this stage to pass any order as prayed for by the petitioner, directing the state to open the places of worship even in the limited manner. The court, however, left it to the state's discretion to take the next course of action. If at all the situation changes for the better, the state has objected to the petition by stating that there is no guarantee that the citizen will abide by the guidelines issued by the state, past experience has demonstrated that all such restrictions have eventually been breached, including during the Ganesh Chaturthi festival this year. It is extremely difficult to monitor the compliance of the restriction that may be issued. The bench orally pointed out that the several examples where the breach of safety restriction had led to a rise in the COVID-19 cases. The judge also noted that previous petitions on the issue have been rejected by the Supreme Court as well. The association was represented by Advocate Dipesh Siroya and the state was represented by Advocate General Ashutosh Kumbhakuni along with government pleader P.P. Kakare. The bench has adjourned the matter by 2 months, after which it may review the situation. Taking suo motu cognizance of the building collapse that took place in Thane's Bhiwandi area, where the death toll has risen to 41, the Bombay High Court expressed pain and sadness at the loss of life. Court issued notice to the State and Municipal Corporation of Greater Mumbai, Division Bench of Chief Justice Dipanga Datta and Justice G.S. Kulkarni appointed Senior Advocate Saran Jagitani along with Advocate Rohan Survey to assist the court in the matter. The said building, known as Jilani Building at Bhiwandi, collapsed at about 3 a.m. on September 21st this year. Court noted that as per the report, this building was not included in the list of dangerous structures, so notified by the Bhiwandi Nizampur Municipal Corporation. The bench observed, if this is true, it is unfortunate that no action was taken by the municipal authorities to get the building vacated. It is also reported that this building was constructed sometime in the year 1984 before the municipal corporation was formed, and later on 2 illegal floors came to be constructed. However, no action was taken by any of the municipal authorities and its officers. Court said prima facie opinion it would be an absolute obligation of the municipal corporation and its officers, and more particularly the ward officer within whose jurisdiction such buildings are located and who are presumed to have complete knowledge of the condition of the building, to take timely steps. While observing that prostitution has not been made an offence under Immoral Traffic Prevention Act 1956 and that an adult woman has the right to choose her vocation and cannot be detained without her consent, the Bombay High Court set 3 sex workers from the corrective institution. The court said that the Act does not empower the magistrate to hold the custody of the victims beyond the period of 3 weeks without there being any final order to that effect after following due process of law. The court then observed that Section 17(4) of the said Act provides that after completion of the inquiry, if the magistrate is satisfied, he may, subject to the provision of subsection 5, make an order that the victim be detained for such period being not less than 1 year and not more than 3 years, as may be specified in the order, in a protective home for which the magistrate shall give reason in the writing. It is pertinent to note that the court observed and that the provision of Section 17(4) of the Act are subjected to the provision of subsection 5, which provides that the inquiry shall be conducted by the panel of at least 5 persons to be appointed in the manner of contemplated in the said subsection 5. No such inquiry as contemplated under the statute was conducted in this case. The court also noted that Section 17(4) implies that an order under the said section can only be passed subject to provision of subsection 5, Section 17 of the said Act. In view of multiple comorbid illness and high chances of getting COVID-19 infection in the prison, the Madras High Court has directed the concerned authorities to grant 30 days leave to the convict in the Rajiv Gandhi assassination case T. Arputham. The bench of Justice N. Kiru Bakaran and Justice P. Velumurugan noted that the convict had recently availed 60 days leave and the next spell of ordinary leave could be granted to him only from 12 January 2022 in terms of Rule 22(3) of the Tamil Nadu Suspension of Sentence Rule 1982. Taking note of the extraordinary circumstances in this case, however, the court directed the government to invoke its power under Rule 40 of the Suspension of Sentence Rule and grant leave to the convict. The order has come in a petition filed by the convict's mother, who informed that the court that her son was suffering from hypertension since 1996 and other issues due to prolonged incarceration. He is being treated periodically at Government General Hospital for the past 5 years. Due to COVID pandemic, he could not be provided with proper treatment and therefore prayed that he be released on 90 days leave. The court also criticized the authorities for sitting the petitioner's request for so long and deciding the same, that too without recording proper reason, only after a nudge from the court. Arputham, amongst others, was convicted in assassination for former Prime Minister Rajiv Gandhi by the Designate Court No. 1 under Tata Act 1987. He is currently undergoing life imprisonment and has been incarcerated for the past 29 years. The Karnataka High Court has, by way of interim relief, stayed the execution and operation of the order dated 20th July by which the state government directed that the payment of variable tierness allowance will stand deferred from April 1, 2020 till 31st of March 2021. A division bench of Chief Justice Abhay Oka and Justice Ashok S. Kinagi passed the order while hearing a petition filed by Karnataka Industrial and other establishment employees, federation and others. The counsel for the petitioner had argued that though a stand has been taken now by the state government that the exercise of power while passing the impugned order is under subsection 2 of section 26 of the Minimum Wages Act 1948. The impugned order does not say so. The state government countered the argument by saying it is not necessary that the order passed by the state government must contain a reference to a particular provision under which the power is sought to be exercised. If the order can spell out exercise of power under a particular statutory provision of law, that is sufficient. The state government, though, concealed that the order is only deferment of payment of VDA, which is undoubtedly a part of the minimum wages. Further, it was contended that by exercising the power under subsection 2 of the section 26 of the said act, the state government can always specify that certain provision of the said act will not apply to all the classes of employees. The bench concluded that the impugned order, as observed earlier, is ex facie illegal and deserves to be stayed. The Karnataka High Court has pulled up the state government for the poorly drafted rehabilitation scheme that it had come up for illegal evicted migrants in Bangalore. A division bench of Chief Justice Abhay Srinivas Oka and Justice Ashok S. Kinagi asked the state government to come up with a better scheme. We hope and trust that state government comes out with a better scheme, the bench noted in its order. The court further said on the face of it, the rehabilitation scheme has been poorly drafted in as much as clause 1 thereof shows that the state government is not sure whether there are any reason or any litigation which will make the said land unavailable. Moreover, the scheme says that the rehabilitation will only be for 1 year. The court further said that it would go on to appoint a valuator who would assess the loss caused to the petitioner, and compensation can be paid to monetary terms. As the hearing progressed, and the court also questioned the state government on who was responsible for the eviction drive. The court further observed large number of people are residing in shelters and shelters were demolished. State is not able to tell us who demolished it. This is failure of the state machinery. On top of that, you come up with the scheme for regularizing illegal construction for 1 year. The court further said that if this was the case, it would go on to appoint a valuator who would assess the loss caused to the petitioner, and compensation can be paid in monetary terms. The Jharkhand court has quashed the appointment of over 2,400 trained graduate teachers in government secondary school of scheduled district in the state. Made pursuant to an advertisement published in 2016, the High Court found that the challenge appointment notification issued by the governor of the state had granted 100% reservation in the favor of the residents of the scheduled district, which totally ignoring the fundamental rights of citizens residing out of the scheduled district. It was added that such reservation was not permissible under the constitution as the outer limit of 50% of as specified in Indra Swani's case. That's all for Courts Roundup today. Thank you for tuning in. Keep watching APN for more updates from around the nation.
India Legal presents Courts Roundup.